In this video, we'll discuss narrowly tailored policies regarding diversity in the workplace. We live in an interesting time because affirmative action programs that were developed decades ago have increasingly fallen afoul of the courts. So we'll discuss today why that is the case and the kinds of affirmative action policies that the courts find to be acceptable. The first thing we want to do is discuss the concept of strict scrutiny. Strict scrutiny is the highest standard that the courts can apply to a proposed policy that's been passed on the state level or a policy of a business. Strict scrutiny is employed when the court says it's clear that the policy is discriminating on the basis of race or some other sort of factor. Now, that doesn't mean that the policy needs to be rejected. A policy that infringes upon someone's rights can be upheld if the policy can be shown to pass the three standards of strict scrutiny. The first of these is that there has to be a compelling government interest in order to maintain the law. So, for instance, in wartime, there are a number of rights, such as the right to assemble, the right to travel, that are restricted because the government has a compelling interest to restrict those rights for the good of the country. And so, in a unique situation, the government can argue we've got a compelling interest here, and that's why we have to restrict rights in a particular case. The second criterion is that the policy needs to be narrowly tailored, and we'll talk more about what that means in a minute. But what it means, generally speaking, is that the policy affects only the specific issue at stake, and it's not something that is so broadly construed that it's going to impact more rights than it needs to. And then finally, the policy needs to use the least restrictive means of achieving the government's interest in this case. So in one very famous case, Roe v. Wade, the state of Texas was brought up on the courts because they had violated the right to privacy of women who wanted to get an abortion. At least that was the court's final decision. And what was decided in that case was that government does have a compelling interest in the life of the unborn child. However, the court decided that that interest does not begin until the point of viability. So the problem with Texas's law was that it did not yet have a compelling interest to lay aside a woman's right to privacy, not at least until the point of viability. And the law, as it was written, was not narrowly tailored. If it had been written in such a way as to say that abortion will be outlawed after the point of viability and will make exception for saving the life of the mother or for the health concerns of the mother, then the court said it would have been a narrowly tailored position and also would have fulfilled the last criterion of being the least restrictive way of promoting the government's legitimate interest in the life of the unborn child. So we can see the concept of a narrowly tailored policy in the case of Fisher versus the University of Texas. Noelle Fisher was a young woman who was from Texas, graduated from Stephen F. Austin High School, and she applied to the University of Texas and was denied. Why is it that she ends up bringing a court case? Well, in 1997, the University of Texas incorporated an affirmative action plan that was designed to increase student diversity. It actually replaced a more objectionable plan that came before. This plan came to be called the top 10% rule. It was simple. If you graduated in the top 10% of your graduating class of your high school, then you would automatically be accepted to the University of Texas. Now, the reason why this promoted diversity is that people in bad school districts, be it an urban school district or a rural school district, if they worked hard enough to be in the top 10% of their class, they'd be able to go to the University of Texas. And the end result of this policy was that students from more diverse backgrounds became part of the student body at University of Texas. Note that this 10% rule focuses on various geographical areas, socioeconomic classes, experiences, and backgrounds in addition to race. And this is why the U.S. Court of Appeals, the Fifth Circuit, declared that the program was constitutional. It said that the program was narrowly tailored. It wasn't designed purely to increase racial diversity. It was instead narrowly tailored, and it passed the muster of the court. And in this particular decision, they hearkened back to a 2003 Supreme Court case, Grutter versus Bollinger, in which Barbara Grutter, someone who applied to the University of Michigan Law School, argued that she had been unduly denied entrance to the law school because she had a better academic records than people who were admitted because of their race or their gender. What the court said in the case of the University of Michigan Law School was that the policy was narrowly tailored. In other words, it was a policy that fit constitutional muster. It survived the strict scrutiny. And notice that strict scrutiny is required because both in the case of Noel Fisher and in the case of Barbara Grutter, they were denied entrance to a college to at least some degree because of their race. So we start with the fact that they're being discriminated against. And then we have to ask the question, is the policy nevertheless justified? So what does narrowly tailored mean? Narrowly tailored means that race, in the case of the University of Texas and Michigan, was only one rather small factor in the admissions decision. In the exact words of the court, race was not the defining feature of the application to the school. If you had a separate track for minority candidates and for white candidates, that would violate this. But race was determined not to be the defining feature of the application. And the purpose of the decision was to promote a value that was crucial to the purpose of the institution. And in the next slide, we'll talk about the value of diversity to an educational institution. They were not making this decision because they didn't like a member of a certain race. They were saying, we need a more diverse student body that's valuable to us as an educational institution. That was the reason for the decision. And this is generally taken to be acceptable. Educational institutions do this. If I'm a church, I can say, we need to hire a pastor who's a Christian. Or we need to hire a youth minister who's a Christian because of the purpose of our institution. Right? If I'm a modeling agency, I'm going to hire people who are thought beautiful by our clients because they're the ones who are going to try to lure people into buying their products through the use of our models. So I can't go and say, hey, they didn't hire me because I'm unattractive. Well, they have a compelling value here, which is central to their business, which allows them to discriminate. And the same thing can be said for the armed forces that require a certain amount of physical attributes in order to fulfill the purpose of the armed forces. Airlines would only hire people who can really fly a plane well, and it wouldn't make sense to hire people on the basis of any other factor. So the implications of a narrowly tailored policy is that there can be no quota system. You can't say, all right, we're going to hire 20% people from a certain racial background. We're going to hire 50% females. That is unacceptable. It's not going to pass the muster of the courts. Nor is it acceptable in an educational institution to have separate admission tracks.